Order, order. Can I call the committee to order and welcome the Minister for Modern Slavery and Organised Crime.
Thank you.
Minister, we were keen to have you in before Parliament was dissolved. I'm sorry we've kept you so long, so it might sound like a very odd thing to say, but congratulations on your appointment, which was several years ago. It goes to show there has been nothing controversial in your brief, so we didn't need to call you in before now. Today we're looking at the issues of serious and organised crime, including human trafficking. And I'd like to start, if I may, with your work, which members of the House have been very impressed with, on human trafficking. Are you satisfied that the government is doing enough in respect of disrupting those who are trafficking people from different parts of the world into the United Kingdom?
Thank you very much, Keith, and thank you to the committee. And I did begin to think that maybe I would fail to come before you, given your programme of work, and I know how busy you are, so I am very grateful to have the opportunity to be here. And to start with modern slavery, which has been, in the just over 12 months I've been doing this ministerial role, a significant part of my work. I think credit, first of all, should go to those that first raised the issue of human trafficking, and that includes Anthony Steen, Peter Bone, Fiona McTaggart, John Randall, and of course Frank Field, who've been incredibly instrumental in making sure that we were aware of this, but also credit to the Home Secretary for taking this on and making it a real mission to make sure that we are at the forefront of everything happening on modern slavery and human trafficking globally. The programme of activity, which you will know about the Modern Slavery Bill, having all been there for the votes that we had in the House of Commons, is a very comprehensive piece of work, but it's not the only thing that we're doing. And your question, Chair, about am I satisfied that we're doing enough, does link into all the work we're doing through the Modern Slavery Strategy, because I don't think it would be a surprise to anybody in this room, but legislation is only part of the answer. And the bill is incredibly important for raising awareness and for giving law enforcement the tools and weapons they need to be able to get the prosecutions. And I think, the only way we are going to protect victims is by catching and convicting the criminals.
And that is my second point. If you look at the estimates of the human trafficking sector, they say that there are 2,744 people, including 602 children, who are potential victims of exploitation, an increase of 22% on 2012. How do you, as a minister, know that the strategy that's been adopted, the new powers that you've had from Parliament, is actually disrupting these people? Is it numbers you're looking for, numbers of prosecutions? Is it people you liberate from slavery? How do you know that it's been successful?
It's a very, very good question. And the number of people that have been referred into the National Referral Mechanism and the number of people that the Human Trafficking Centre estimate as being victims is not the total of victims here in Britain. We've done some work, Home Office Science did some work taking the information we know and then extrapolating that out to show that the number of victims is between 10 to 13,000. Now, how do we know that we are having success?
Yes.
We will only have success when that number of victims starts to come down.
Right, but that's only an estimate. You see, this is the problem for this committee in looking at this subject. We like to go for prosecutions because people go through the courts, they're sent to jail, you disrupt the organised groups. How many prosecutions did you have for human trafficking last year?
Not enough. I'll be quite blunt with you, not enough.
What's the number?
The number is, and if you forgive me, let me get it, I wouldn't want to give the committee false information, but if I can come back to you with the number in a second. The number is not enough. It hasn't been enough. That's why we want to increase the penalties, and that's why the bill is so important. And one of the problems we have is that some of the victims of trafficking, the Crown Prosecution Service have not prosecuted the perpetrators for human trafficking offences. They have prosecuted them for rape, for instance, where a life sentence is available.
But do we... obviously, someone may pass you a note, which is fine by us, because you can't be expected to know every single figure. But would you know how many people you have then released from modern slavery last year?
The number of people who went through the national referral mechanism. So those are identified victims who've had the support that they need. In 2013 was 1,746, but of those, fewer than half were actually given the conclusive grounds decision, which is one of the reasons we've reviewed the national referral mechanism, because we need to make sure that we are finding as many of those victims, making sure they're referred into the NRM and getting them out at the other side as conclusive grounds victims of slavery, giving them the support and dedicated support that they need.
Thank you. Now, the UK-French agreement on Calais said that ministers will set clear and ambitious targets to ensure the full impact in the fight against organised immigration crime. Mr. Lawton and I and Mr. Winnick went to Calais, and it was very clear to us that this was organised trafficking. Illegal migrants, and this is quoting from the Telegraph of the 29th of October, were asked to choose from a package, a classic package, which meant they travelled on the back of a lorry for £2,000, or a guaranteed VIP route in which migrants crossed in a car with a complicit driver of £4,000. This is organised immigration crime, and Mr. Ellis will deal with other aspects when he gets to ask his question. But if you just concentrate on Calais, how are we disrupting these people who've made an industry out of bringing illegal migrants from Calais?
And it's not just Calais. I mean, clearly, Chair, I will talk about Calais, but it's not just Calais, because we know, for example, in Albania that there is significant industry of organised criminals who work to create backstories for unaccompanied asylum-seeking children and for victims of slavery. And we must not allow ourselves to be in a position where we are fueling that demand. We have to make sure that we give the right support to victims, that we target the perpetrators, not the victims, and that's why the statutory defence in the bill is so important.
How many people have you prosecuted as a result of activities in Calais?
I don't have that number to hand, but I will, of course, write to you.
One final question from me on the NCA, because we've got Keith Bristow in. Now, you're the Minister for the National Crime Agency. We're a fan of the National... We like the National Crime Agency. However, we are concerned about asset seizures. Now, we're very concerned that in the Evening Standard tonight, Keith Bristow has said that he doesn't think that the NCA is going to be able to recover anything like the 1.3 billion that is owed to the taxpayer by serious criminals. He doesn't think that's going to be recovered. So we have an organisation that costs us £500 million a year that now tells us, we've got Mr. Bristow in later so he can answer for himself, that we're going to get nothing like the 1.3 billion that people owe the taxpayer. Indeed, he says that only 124 million of that figure is likely to be ever seized. Now, that's a very small amount of money when you look at what is owed. Are you concerned about this?
I have been concerned about asset recovery since the first day I came into the job, and in fact one of the very first tasks I undertook was to visit Spain, to visit Madrid, where the CPS and other prosecution services were working with the Spanish to determine what were the barriers that stop us recovering the money. Because the problem is that this is a technical, legal issue.
Sure. But why have a law that says to criminals, we are going to seize your property and assets, knowing full well that we're never going to seize their property and assets? It may be technical and complicated, most laws are. Why have a law that does that? Why have an agency that's chasing them when we know we're never going to get the money back?
Well, I don't accept that we can never recover
Mr.
the
Bristow
assets.
says that.
But if I can just refer to that point, we did ask the National Crime Agency to look at what was recoverable, because they have inherited an enormous stock, shall we call it, of unrecovered debts, some of which are over 10 years old. Right. And I think it's important that we understand what is recoverable of that stock. But what I'm interested in as well is the flow. And I need to make sure that when courts, and I want to see courts issue more confiscation orders...
What's the point if we can't get the money? What's the point of issuing? We understand your passion, but if the agency... We don't expect you to go out and seize these assets. You set the parameters and you do it with great dedication. But your staff in the NCA are costing the taxpayer £500 million. What's the point of having more laws confiscating when we can't get the money that is owed to us now?
Well, what I was coming on to say was that the way that we are changing the laws, the way we change the laws, and the way also the Criminal Finances Board that I chair works is to work across all the agencies that are involved in this in the recovery. So clearly, we want courts to issue confiscation orders for realistic amounts of assets that can be recovered.
Concerned about this?
Of course, very concerned.
And you think it should be higher?
And that's why we have a criminal...
Do you think it should be higher?
That's why we have a criminal finances improvement plan to make sure that we do recover the maximum amount we possibly can.
But do you think that asset recovery should be higher than it is?
Yes.
And, you know, the final fact to put to you is that 176 serious criminals owe us £695 million. They've served their jail sentence, they're out of jail, but they still owe the taxpayer £695 million. Would you be able to have access to that list of 176 people? Would ministers know about this list?
I don't have the operational details, but I do...
These are people convicted, this is not operational.
No, but I do have the ability to access that kind of information. But that's why we brought the changes into the Serious Crime Bill, because you're quite right that criminals were able to serve their time in jail and walk away. And for many... jail is an occupational hazard. Losing their assets is a much bigger deterrent.
So can you assure us that the 176, once they come out of jail, who owe the taxpayer £695 million, aren't able to come in and out of the country? Are there any restrictions placed on them?
I would have to look at the individuals in question. I can't give you that answer as a blanket. I would have to look at who they are.
If you could do that, if you could let us have your answers by next week.
Of course.
By Monday of next week, it would help us, because we're not going to be around that long. So, very helpful. Mr. Ellis. Sorry, Dr.
Chair, you will be around forever. I know you will.
Flattery will get you everywhere. Dr. Hubbard, as a quick supplementary, then Mr. Ellis, you have the floor.
Just very briefly, the Chair's question has touched on something I've been into, which is restrained assets, where for a number of these people, we have been paying their legal aid costs because we don't allow them to use money. Have you considered looking at changing those rules? Because it certainly seems to me that some of these people might be more able to find the assets they wish to use if they're allowed to use at least some of them in their own defence.
We have changed the rules about the availability to criminals of the Rolls-Royce solicitors, as it was described during the progress of the Serious Crime Bill. We did have to make the point, as one of our members of the committee represented Rolls-Royce, another represented Bentley, that they were both equally good vehicles. But we have made it so that criminals cannot employ extremely expensive barristers, getting full recovery of that, the costs of those barristers against the assets that have been restrained. So we have done that. And we've also made other steps to make sure that we have the ability to access those assets as quickly as possible, that we can't have the third-party claims on those assets, and that criminals do... It's not an unfair system where criminals are able to access enhanced legal support over and above their victims. Because actually, the important thing here is not just confiscating assets, but giving compensation to the victims. That is incredibly important.
Thank you. Ms. Michael Ellis.
Thank you very much. I think it's right, isn't it, Minister, that sometimes just giving a bare figure of a number of prosecutions can be somewhat deceptive, because the Crown Prosecution Service is responsible for prosecutions in this country wholly independently of ministers of the Crown, and rightly so. And they sometimes end up charging individuals, or shall I say prosecuting individuals, for different offences that are subsumed within the overall offence of human trafficking. As I think you alluded to yourself, it might be a sexual offence, it might be false imprisonment, it might be assault of some sort. So an overall figure can be somewhat deceptive. But do you accept that there's more that can be done in this area in terms of the number of prosecutions that are commenced in this area?
Absolutely, yes. And the one thing one of the many things that I want to see come from this, and part of the work that I've been doing through the strategy, through the operational leads meeting that I hold monthly, is to make sure the CPS are taking action where it is possible. Now, the big problem we have with so many of these cases is getting the evidence. And as you said, Mr. Ellis, and I well understand why a prosecutor would prosecute for rape when it's going to give them life imprisonment, whereas human trafficking would be only 14 years until the bill becomes an Act of Parliament. But the very clear message that I have given to the Crown Prosecution Service, as have others, including the Solicitor General and the Attorney General, is that we do want to see prosecutions for human trafficking and modern slavery offences going through the courts more and more. And we also want to make sure that they are properly marked and flagged, and that's one of the roles that the Anti-Slavery Commissioner is working on, to Independent Anti-Slavery Commissioner designate, I should say, to make sure that we do have information about
because that would help statistics. It would help a proper overview of the situation. If you've got a record that, for example, a rape prosecution stemmed from a human trafficking prosecution and it's part of that allegation, then that would help record keeping.
And let's be blunt, we want to get prosecutions. And if it's more likely to get the prosecution for a charge of rape, I want that prosecution.
And as far as confiscation orders are concerned, these are ultimately up to the judge, are they not, to make such an order? Have you perceived a reluctance on the part of the judiciary generally to make confiscation orders, for example, if they're persuaded that there are no assets or insufficient assets of the defendant in front of them? They don't make a confiscation order at all, and that clearly is not desirable.
Again, Mr. Ellis, you're right, and I bow to your greater knowledge of the court system than mine, but there has been a reluctance, no doubt about it, in courts to put confiscations orders on where the courts could not, did not have sufficient certainty about the level of assets and that there would be recovery. And again, we do want to make sure that courts do not take that approach, that they do put the confiscations orders on. The Crown Prosecution Service are part of the Criminal Finances Board, and they do understand that
you're
this is
liaising with the law officers of the Crown
are.
about that, are you, in
Yes.
terms of trying to impact on the judges the importance of these confiscation
Yes.
orders? Can I just ask you two more quick points? And one of them is this. What action is government taking to disrupt human trafficking further afield from these shores? So, for example, the known migrant routes into the EU from places like Libya and Turkey. Are we able to take any action there?
We are. We have, working with the Foreign and Commonwealth Office and the Department for International Development, where the source countries are also development countries. We are working with our embassies, we are working with high commissions to make sure that all information that is known about the smuggling of people comes to light. And the National Crime Agency, one of the things I have been most impressed about with the National Crime Agency is that, I mean, as you can imagine, as the Minister for Serious and Organised Crime, my road trips don't tend to be to the glamour spots. They tend to be places where there is serious and organised crime. But there is always a very competent, embedded National Crime Agency officer working with the local police there.
And I think this committee's had good experience with the National Crime Agency.
And they are completely, as I say, embedded with local police and working with them to find those criminals that are facilitating the immigration crime.
Finally, from me, I'm concerned and have been concerned for a time about the issue of modern overseas domestic service. Those that come into this country for domestic service from overseas, and they end up being, if you like, legitimately brought into the country possibly, but there ends up being an element of modern slavery within how they're treated whilst in this country. Now, how can we deal with that? What are you doing as Minister in that area?
Thank you for that question, because it's very pertinent. The Modern Slavery Bill covers all victims of slavery, all victims of domestic servitude, forced or compulsory labour and slavery. And I want there to be no doubt that any victim of slavery is covered by that by the bill. there have been a number of concerns raised about the overseas domestic workers visa route. It's probably just worth saying that this is a route that enables people coming to visit the UK for a short period of time, a period of up to 6 months, to bring with them their domestic staff. For example, it might be the children's nanny. It may be a cook. It may be somebody that they feel they need to have in their entourage. And we've had reports for many years of there being abuse within that system. Now, let's put this in context. Before 2012, the charity Calayan, which I know has been very vocal in this area, was receiving about 300 people a year coming to them saying they were victims of abuse within an overseas domestic workers context. In 2012, we changed the visa arrangements, so we tied the visa to one employer, partly to try and stop the abuse of people being brought in by organised criminals and then being taken on by other employers. Calayan are still reporting that there is abuse. About 60 people a year, they say, are coming forward. Now,
how many come into the country?
The total number who come into the country is 15,000 visas a year are issued. And the best evidence we have is that the average length of stay is 15 days. Now, the difficulty we have is how do we best find those people, make sure they're not suffering abuse, make sure that they know what support is available to them, make sure we're not importing abuse. Some have said that the tied visa is the reason. I can't see the logical argument for that. There was definitely abuse before the tied visa. There is still abuse. And if it was just the right to change employer, we would have no UK nationals.
Are there target countries that where we're seeing this as a particular problem, who are applying for these visas, domestic service visas?
Well, not in terms of the numbers coming forward that go through the national referral mechanism. There's no sort of one country coming through. But what we have done, because I am very concerned about this, and I do want to make sure we do the right thing and we find these people and we stop them being abused. So we've asked James Ewens, who was an advisor to the Pre-Legislative Scrutiny Committee, a barrister, very well respected in this field, I hope you'll agree. We've asked him to conduct a review of the whole visa arrangements so that we can make sure we can deal with this, because the problem of finding those 15,000 people and making sure they're not abused is not easy.
Thank you very much. Thank you, Mr. Ellis. Nicola Blackwood and then James Clappers.
Ms. Bradley, you mentioned earlier that one of the challenges with prosecuting trafficking is getting the evidence and the investigative process, but we've taken a number of steps in recent legislation to try and assist with that, with reforming the civil prevention orders. We've brought in the sexual harm and prevention orders, the sexual risk orders, the slavery and trafficking prevention orders, and we've changed the thresholds for the gang injunctions. Now, these are all new orders. I'm wondering what steps you're going to be taking to make sure that there's very good guidance in place and very good training in place, and what discussions you've had with the College of Policing to make sure that these are well used and that there's a proper process in place to move from administrative orders like the corns so that they are used not just as steps in themselves but also as an appropriate pathway to investigation and prosecution.
Thank you for that, and I want to pay tribute to the work you have done, and certainly my experiences of visiting the team that had worked on Operation Bullfinch with you were incredibly helpful in terms of shaping the bill, because there's the modern slavery bill, because there is so much that we can learn from the experiences of other abuse and other organised crime gangs abusing young people in this way. The civil orders that have been introduced are part of the protect side of the work that we're doing. And if I focus perhaps on the slavery ones for now, and we can talk about the other work with all of the College of Policing, one of the big challenges is how do we get a custody sergeant to identify that the person that they've come into contact with is a victim, not a criminal? How do we get the teacher to recognise that there is a victim there, and that this person going home every night isn't going home, they're going to an organised crime group who are trafficking them for sexual purposes, for labour purposes, etc. And that is an enormous challenge, because it means it becoming second nature to local police forces up and down the country to know what to look for. The College of Policing are part of our operational leads team and do attend. I have regular meetings with College of Policing to make sure that we are developing the right training courses and that training is being rolled out appropriately. And the guidance, as you rightly say, is so incredibly important because it needs to be clear. And I mean, one example of guidance I would give is that when I visited the Human Trafficking Centre in that the National Crime Agency run, they have an investigative advice team that local officers can go to. And I was slightly concerned as to what sort of advice is being given to local officers. If they've come to the Human Trafficking Centre, do they have enough knowledge? I mean, it's good that they've actually said this might be trafficking, but then what do they get in return? And I was very pleased to see an incredibly comprehensive and layman's terms description sent back to those police officers to explain the kind of things they may be seeing, the kind of things they should look for, and the tools that are available to them, including protection orders, to make sure that those local police on the front line did know what was available.
Well, I think that one of the risks which was raised when the first of these orders was put through the House and subsequent ones is that these orders would become almost an easy substitute for moving forward to prosecution. And police who I've spoken to subsequently tell me that one of the biggest challenges with grooming victims and others is that they need almost a breathing space between the abuse and between going through sort of the investigative and prosecution period, so that they can reflect back and say, hang on a second, that wasn't right, what happened to me was wrong, and I want to go through the justice process. And these orders can allow that breathing space, but they're not going to do that if they become the end of the story. And so I want to know what steps are being put in place to make sure that they don't become the end of the story and they do become part of sort of a much longer process moving towards a full justice outcome.
I think it is a very, very good point. If you wouldn't mind, because I don't want to detain the committee too long, but perhaps I could write to you on that specific point as well.
That would be very helpful. Thank you. James Claverson.
Well, I was going to ask about the regional crime units aspects of the National Crime Agency, but I think you've told us that you're broadly satisfied with that and there's a good cooperation going on between the two. Is that right?
Yes, I am. I've visited 3 of the regional crime units, regional organised crime units, over the last 6 months, because I want to see for myself how we are getting that connection between the National Crime Agency and their international connections down to local force level. And of course, as you will know, the ROCUs are they're actually local force led. They're accountable to police and crime commissioners and chief constables, but they take the National Crime Agency into the regional organised crime unit, and they therefore give that link between the two. Now, of the 3 I visited, they all have slightly different models. They all have a slightly different approach, which is right for them given their situation. For example, the South East Regional Organised Crime Unit, which is the forces that sort of go around London, doesn't have one big major urban centre, but the West Midlands one, which covers my own force of Staffordshire, of course has West Midlands with that big urban centre in the middle of Birmingham, and therefore it's quite right that those units should be set up in a way that works for those local police forces. And certainly the visits I've had and the discussions I've had with both National Crime Agency officers, but also multi-agency work, people who work in the border force. I've met trading standards people in the regional organised crime units. I've met National Crime Agency. I've met very many different types of people all working together from different agencies, and it does seem to work. The experience I've had is that it's working coherently, and that there is an understanding of how those specialist capabilities that the NCA have can be transferred down to local level in an effective way through the ROCU that doesn't dilute anything local police forces are doing.
On a different subject, I wonder, do your responsibilities encompass taking a lead internationally against modern slavery, and do you liaise with the Foreign Office on that? I'm asking that question against a background where, sadly, slavery seems to be far too prevalent in the world today, and in some parts of the world even making a comeback. This country and this government has a good record on it, but are we taking enough of an international stand on it?
We are. The Foreign and Commonwealth Office are part of the interministerial group that we have that leads in the UK on terms of responsibility for delivering on slavery, and Baroness Annerly has been absolutely instrumental in her work to make sure that embassies, high commissions, etc. have the knowledge and information. But we also have worked with the churches. It's not just about embassies. We're working with the Santa Marta Conference, which is a group set up by the Pope and which has representatives from the Catholic Church and the Anglican Church and law enforcement from across the world. London hosted the first Santa Marta conference in December to look at how we can all work together. And there's very many organisations we're working with. One of them is Rotary. Rotary is an incredibly powerful organisation because Rotary have chapters, I think is the right word, everywhere in the world. There is a Rotary, and Rotary therefore can be working on the ground to identify what the problems are of slavery, to see what slavery looks like in those countries, and working with us and with the churches and with the Foreign and Commonwealth Office to tackle it.
Very helpful. Dr. Hubbard.
Thank you, Chair. Can I turn to issues about the cybercrime strategy the government has? I think you're responsible for that among a huge range of other things. The evidence that has come out recently, there was a survey last year for Get Safe Online Week, which said that roughly half of the people surveyed said they'd been a victim of online crime. Huge sums for online fraud. I don't know if you have a current estimate. What is the strategy doing to tackle this so far?
With cyber, I think it's important to distinguish between the two types, the cyber-enabled and the cyber-dependent. So the cyber-enabled crime is the online fraud. So that would be somebody, going online and buying something off a fake seller on the internet, or receiving an email from somebody and sending them money, or possibly even sort of online trolling and abuse online, and that it's the same crime, as we know, that would happen in the street. If someone goes to Leek Market and gives a vendor £2,000...
We've done an inquiry into this.
Yes, yeah, so you understand. So if we look at the online fraud side of things, then that comes very much to the work that City of London Police are leading on with Action Fraud, the National Fraud Investigation Bureau, and making sure that also local policing understands, and this is again a College of Policing piece of work, to make sure that there is sufficient training locally for people to be able to say what's the fingerprints you'd look for. You'd look for a fingerprint on a physical fraud. What's the online fingerprint? What's the digital fingerprint you're looking for? If we turn then to the cyber enabled side of crime, which is cyber dependent, yes. But that is always the one. But but the malware. That needs a much more technical capability, and that's where the ROCUs come in, actually, because the ROCUs have within each of them a cybercrime unit of highly skilled technical specialists, which local policing can access for that sort of very high level crime. And obviously you'll know about the two...
Dr. Hubbard?
This is all very interesting, but do you think we're doing better than we were 5 years ago?
Well,
how would you measure that?
I was just coming on to say the National Crime Agency has made a big difference with the National Cybercrime Unit, having been involved in the two big operations last year, but two big international operations, the TOVAR operation, which was Game Over Zeus and Crypto Locker, and then the Project Disputed, which was actually NCA-led, the first time that any of these operations have been led from outside the US, and it was the NCA that led it, which was the Shylock malware. I think that actually in the National Crime Agency and the National Cybercrime Unit, we do have world leaders in that field, and I'm very pleased with the work that's gone on so far, but that's not to say that we shouldn't always be doing more.
It seems to me like we're just sort of scratching the surface slightly. I mean, do you have estimates of the value, for example, or the number of incidents that are happening each year, whether that's been going up or down over the last 5 years?
We have what's reported into Action Fraud, and obviously we have what... so are you talking about the cyber crime or the online fraud?
I think I have the same problem with both of them, which is that there are a few very interesting cases, and I absolutely accept the ones that you've given, But overall, all the evidence that I've seen suggests there is a vast amount which is never reported, which is never tackled, which is just not dealt with at all. Do you have any confidence that we're actually making inroads on any of these categories?
I do have confidence we're making inroads, and I absolutely agree with you. We need to do more. I'm not saying that we have reached the end of the story and that there's not more we can do, but I do feel confident that the work we've done so far and the work that the Action Forward and National Forward Investigation Bureau are doing, we have lots of work with them through the Cybercrime Board to make sure that we understand the victim experience, we understand that we make sure reports are made and that there is ownership of those reports. There is a long way to go, but I am confident we're on the right track.
And the other side is of course, cyber security and making sure that people are defended. The government's cyber security strategy talks about the use of privacy-enhancing technology and systems that can be very helpful in this, so encrypting messages and things like that. Is it still government policy to encourage that?
In the cyber security strategy, we have a lot of work about raising awareness about how people can protect themselves online. You'll know the statistic, 80% of all online crime can be stopped by simple disinfectant, as GCHQ would tell you. So Cyber Streetwise, for example, is there to increase that. We've also introduced Cyber Essentials, which is a programme that business can go through to get to say that they are as safe online as it's to do business with online it's possible to be. We have the CISP, which is a place where businesses can share information in a safe space about cyber attacks. And we also have the CERT, which is the I'm going to get the initials wrong if I don't check exactly what CERT stands for. It's the emergency response team, and that is there so when there is cyber attack, that team can go out and make sure that they are giving business the safety that they need, because actually the evidence is that most businesses don't know they've had a cyber attack till at least 48 hours after the attack has taken place. So we've got a number of places where we are working with business and making sure that people and businesses are safe.
This is very much business focused rather than consumer focused. But so your aim is still to encourage individuals to encrypt communications so that they are more resilient. Is that still the strategy?
The aim is to make sure that everybody has the awareness of cybersecurity and that people are updating their malware and that they are doing simple things like changing passwords. That's the work we're doing on Cyber Streetwise and the Cyber Essentials programme.
Thank you. David Willick.
Child sexual exploitation. Minister, obviously it's a problem to say the least. We're all united in trying to combat a notorious evil. Can I just first of all ask you, how far as a minister, as an MP, as indeed as a private individual before you became active in public life, were you aware of the extent of sexual exploitation amongst children?
I think we're all only just getting to grips with the extent of it, aren't we? I think that if you ask me what I knew about it in 2010 before I was a Member of Parliament, the answer would be very little. I knew that I would want my children to be safe online. I knew about certain protections, but I didn't know the extent of it. It's only now, as a minister, that I'm starting to see...
That's a frank answer, because it would be more or less the answer that I would give, and I've been in public life, age-wise, obviously, far greater than you, but... So you would agree that the sheer extent of of what has been revealed all around the country to some extent, but in certain particular spots which have been much publicised, and rightly so, and the Jimmy Savile horrors and the rest of it, you weren't aware anywhere near the extent to which it took place?
No, and I don't think any of us were. I think it's been a dreadful, horrible shock to everybody, and one only has to just scratch the surface of some of the reports that we've seen of what's happened in the Rotherham report recently, for example, to be absolutely and totally horrified by the failings by so many for so long to protect children.
Now, as I say, we're all agreed that it has to be combated and indeed, presumably, to what is taking place at this very moment. It hasn't ended because of the inquiries into what occurred years previously. Now, this unit which has been set up, National Crime and GCHQ, a specialist unit, how far will it differ from what the police and other agencies are dealing with, child sexual exploitation?
Well, from the National Crime Agency point of view, there are a number of different sides to the investigative work that they carry out. There's the Child Exploitation and Online Protection, the CEOP team, that used to be a standalone team, has been brought into the National Crime Agency, which were responsible for the work, the Operation Notarise, that we've seen so many arrests through recently. In terms of the work with GCHQ, having spoken to the director at the National Crime Agency with responsibility for this area, what GCHQ is able to give the National Crime Agency is increased capability to find and identify the possible perpetrators of this crime. Because the difficulty we have is the online side of things, and it was put to me very... I suppose it made me very nervous when it was put to me by one of the National Crime Agency's officers that the internet allows, if I go back to when I was a child and there would be strange people hanging around outside the school, you almost laughed at them. You thought they were a bit weird, they were strange. Society didn't allow them to behave in the way they may have wanted to. It was not acceptable. But what the internet does is it allows a safe place for people to go. It normalises the behaviour, it socialises the behaviour, and it anonymises the behaviour. And therefore it gives people who would never behave in that way in tangible life, shall we call it, the place they can go and view images that are completely and totally unacceptable. And what GCHQ offers is the capabilities to find those people in a way that policing, standalone policing, could not do.
So the dark web, as it's called, obviously meant to disguise the identity of a culprit or the rest of it. This unit which I've mentioned is dealing with that, or is going to deal with it. I'm not quite sure. Is this unit up and running?
They've been working together. I'm not sure that there's an official unit as such, but there's the CEOP unit, the CEOP Command, which is part of the National Crime Agency, is working with GCHQ, amongst others, to tackle this crime.
Thank you.
Thank you. Tim Morgan.
Minister, can we talk about the National Crime Agency and its record on trials and fraud in particular? And there was a rather notorious case just before Christmas where the judge, Wendy Joseph, criticised the NCA and saying they'd failed the public interest in this case. There was no excuse or justification for the combination of multiple failures that have occurred. And she said that evidence had gone missing, it was misleading, or had not been investigated properly in the complex fraud inquiry that she was presiding over, and those being prosecuted sort of laughed their way out of court. That was quite a damning indictment of the NCA. So what have you made of their performance so far with such high-profile cases revealing some quite severe case of incompetence?
I'm not sure which case you're referring to. I just wonder if do you know the name of the case?
Norton.
Well, that's a very good point. It was in London. I have the article here that appeared in The Guardian, which is probably why you and I didn't see it the first time around. It happened in December. There were 7 defendants.
It was that one. That's right. I thought it was the one I was thinking.
It was a £5 million
yes.
Fraud case.
I mean, it was. First of all, nobody wanted to see the trial fail. It was a very large and complex case, and I know that the NCA and the CPS have been reviewing the case to identify the lessons that can be learned. And we certainly do need to learn from the case, because we don't want to see those kind of trials fail when clearly the CPS have felt that they had the evidence that made it worthwhile to take the case to court. I mean, the judge was critical, but we have worked with the NCA to make sure we are dealing with the failings that were identified and investing in capabilities and skills. And of course, one of the criticisms was about the IT systems. The Novo project, which is a transformation project to bring all of those precursor agencies that came into the NCA to make them into one workforce, into one law enforcement agency, is underway to make sure that the IT systems all do work together. In fact, we end up with just one overarching IT system by the end.
I think the point in this case, it was obviously a complex fraud case, but it was a big case. It involved fraud of over £40 million, involving some quite big institutions, involving people like Chester Zoo and Care UK, I see, and more than 200 bank accounts. But the criticism from the judge that led to the case collapsing was some fairly fundamental investigative work had not been carried out at the outset. So that's not just a question of some oversights. It was some fundamental incompetence that she criticised. Now, what has happened since that case? Has the government taken it as a test case to investigate whether the NCA is really up to doing the job that it's tasked to do?
We're working with the NCA to go through those failings and to see what needs to be done to address those issues. We're also looking at the whole of the government's approach to economic crime and corruption, and we are reviewing overall all the agencies that are involved in dealing and tackling economic crime, fraud and corruption, because it is a slightly fragmented picture at the moment, and I think we all agree that we need to have a more coherent picture, and we need to have agencies working together so we don't end up with criticisms like that in the future.
Okay, but economic crime is one of the four main commands of the NCA, so it's one of the main pillars on which the NCA was put together and tasked to pursue those sorts of cases. There was criticism at the time about whether absorbing CEOPS into the NCA was the best way of being able to specialise in some of these really difficult online child exploitation cases. Are you confident that there is the expertise within the NCA properly to pursue some of these cases of economic crime, which inevitably are going to be quite complex, but do at the very basic require that sort of initial investigative work to be done properly? And in this case, it clearly wasn't.
I am confident. Donald Toone, who has taken over the Economic Crime Command in the National Crime Agency, is a real expert in this area, and he's been working with all the agencies, but also with the financial institutions to make sure that we are getting the right information from them and that we are able to find those criminals in the most efficient and effective way. But you talk about CEOP coming in, and is it right that CEOP should be in the National Crime Agency? And I am absolutely confident, having spent time talking to both to all the leadership within the National Crime Agency, but in particular the leadership within the CEOP Command and the Economic Crime Command, that the investigative skills they share are more than they are that set them apart. So there does need to be technical expertise, but the fact that when there is a big case, each of the commands can pull in capabilities, can use those capabilities, can use the capacity of the bigger National Crime Agency to fight those crimes and to pursue those criminals, I think is absolutely the right thing to do.
Very helpful. Two quick questions, if I could have some quick answers from you on this. In response to what was being said by Michael Ellis, the Egyptian ambassador has said that Egypt needs more support from our government. The boat people who are coming over for immigration purposes are trying to cross the Mediterranean, he says. he thinks that in the next few weeks this will consist of boatloads of terrorists who will be put in the boats and sent over primarily to Italy. Clearly, you've identified the problem. This is a North African issue. In answer to Mr. Ellis, you talked to us about the cooperation that is being done. But this is a pretty critical issue for countries like Italy and Greece, because we're talking about thousands of migrants leaving countries like Egypt. What are we doing in Egypt? What are we doing with Egypt? Because it's those kinds of countries that really need help, isn't it? You're right, it's the source countries. Yep. But is there any practical help we can give Egypt?
Yeah, there is practical help we can give at all levels, and it has to be
what is it?
An upstream approach. We need to have on the ground National Crime Agency,
in
Border
Egypt.
Force and others working with the national agencies, not necessarily located in Egypt. I couldn't tell you off the top of my head whether we have somebody based in Egypt full time, but certainly working in the area, working in the region to make sure that we have got the right intelligence so that we can find those criminals. But we have to do this across the whole EU, of course.
Of course, and it's an EU problem primarily, not just a British problem. And it is the EU that needs to be, Frontex needs to be right at the forefront of this. We understand that. But you're telling us by putting people in the North African area, this is the best way of getting at these people traffickers.
Well, we are part of the Khartoum process, of course.
Yes,
so
but that's some people say that's just we're all part of some process or another, but rather like the Euromed process, it's a conference, the Khartoum process.
No, but it's also about how we actively work together. So it has to be tackled in the source country.
Sure, we agree with you on that. Finally, in terms of the NCA and child abuse, ministers have been very clear that if there is a case that has to be investigated, the NCA must investigate. The NCA is saying something different. It says there are too many cases. 50,000 names originally came over from Toronto, and they can't look at every single case and investigate every single case. How are we going to bridge that gap with ministers saying, quite rightly in our view, you've got to go after everybody, and the NCA saying, sorry, we don't have the resources. We're going to have to leave some of the low-lying crime when, for example, the images of children, the erotic images of children, they don't think is enough to merit an investigation. It has to be more serious than that. What is your message on this?
Well,
Is it still the case that ministers want them all investigated?
I think the first thing is that the 50,000 number is a red herring. It's like the 13,000 number of victims of slavery. It's the best estimate, but we don't have 50,000 names like we don't have the names of 13,000 victims of slavery.
So what are the numbers of names?
But what we do need to do is make sure that the National Crime Agency is investigating and prioritising. And what I do want to make sure is that anybody who
so investigating
may be a contact,
and prioritising, not going after everyone.
Anybody who might be a contact offender, who is in a privileged position, anybody who poses the greatest risk needs to be the priority. And I want to make sure that National Crime Agency or local policing, where it is appropriate, is investigating everybody Minister, who poses a risk to children.
The Home Office has specifically said they want all the crimes investigated. You're now saying you want it to be a priority for some of them.
I'm saying I want all the crimes investigated, but I want the National Crime Agency to prioritise those that pose the most risk.
And if the 50,000 figure is wrong, what's the figure you're giving the committee today?
There is no figure of the number of names. The 50,000 is the best estimate of the number of people within the United Kingdom who may be accessing this information.
So it's
it's not a number of names.
Sure. I mean, most of your portfolio is dealing with estimating the number of people on human trafficking, etc. So that's very helpful indeed. Thank you so much for coming. I'm glad we were able to see you.
Thank you.
And I'll be very grateful to have those answers by midday on Monday.
Thank you very much. Thank you to the committee.
Thank you. Order. Could we have Mr. Keith Bristow, please? than we anticipated. We're most grateful to you for coming in. Can I start with an article that's in this evening's Evening Standard, in which you are reported as saying that you think that only £124 million of the £1.46 billion of confiscation order debts will ever be seized. Do you want to clarify that? Because it's a little depressing. Must be very gleefully received by some who've had confiscation orders, but a bit depressing for this committee because we're a great fan of the National Crime Agency and the work that you're doing. And if you are saying that only 124 million is going to be seized, we get a bit worried.
Chairman, it's accurately reported. There's a bit of context I'd like to share with you, if I may. So, the valuation that's been put on unenforced confiscation orders is done by the Court Service, who are responsible with the CPS for enforcing those orders. And they value it, as you say, at just under 1.5 billion. The value of the orders, of course, is the amount of criminal profit that a criminal derived from their activities at the point where the order was made. That is different to how much asset is actually available to be recovered. So if there was a judgment that a criminal had benefited by 10 million, the order that we would seek under the current regime would be for 10 million, even if they only had £1 million worth of assets to pursue. And the point that I was making in the interview is that when one looks at the cumulative effect of that, plus 8% interest a year on unenforced orders, some of which are frankly not enforceable because the asset doesn't exist, there is a big gap between the outstanding orders and what is likely to be recovered. Sure. And the point I was making to the reporter is that working with our partners, we've identified 161 priority cases, which are active criminals who we think have got assets that we can take off them, and there's outstanding orders, and we think there's £124 million worth of recoverable asset that they still have. And so far, together, not just the NCA, together with CPS, courts, regional asset recovery teams and the SFO, we've taken £40 million back.
But you understand how expectations are raised for the public when they hear that that 1.3 billion is owed to the taxpayer and the courts have issued these confiscation orders, and then you say that it's only 124 that is recoverable. I understand the point that you're making, but you understand the expectations are raised and then dashed as to the amount that's to be recovered.
Of course, if one looks back at the history of asset confiscation, and many of the orders that are outstanding go back many, many years, including before the current legislation,
yes.
The focus in the early days was on getting as many orders as possible for the greatest value possible. Hence, we have a legacy, and I'm being straightforward, that I don't believe that sort of amount is enforceable because I don't think the asset exists to recover.
Sure.
What we are doing is focusing on recovering the assets that are in criminal hands now that can disrupt their activities.
Yes. Now, in respect of the 176 serious criminals who owe £695 million, do we know who these people are? You, as the head of the National Crime Agency, would know who these people are.
Yes, if there's an order outstanding against a convicted criminal, we would know who those individuals are, and we've prioritised 161 of those where we think they've got assets and we think they are dangerous people who ought to be targeted.
And you say they've got 695 million that you'd like to get your hands on?
No, I'm saying those 161 cases that we prioritised have 124 million, and we've taken 40 million off them already.
Sure. Now, are these people allowed to enter and leave the country freely? They finish their sentence, they've gone to court, finished their sentence, they still owe millions of pounds to the British taxpayer in confiscation fines. There's no restrictions on them, presumably, opening a new business or conducting themselves in any way they like, because obviously they're not subject to any court orders, are they?
Unless they've been banned from being directors, perhaps, but for the most part, if they have served their sentence and they are back out at liberty, then they are at liberty.
And they're at liberty to enter and leave the country freely?
Yes.
What can we do to help you, Mr. Bristow, to squeeze them more, having gone through the judicial process? What changes of law would you like to see that this committee can recommend in this very short report that we're doing in order to help you do your job better, to squeeze the last pound out of these people? Because, of course, as you know, the National Audit Office and the Public Accounts Committee have said that only 26p of every £100 worth of orders is currently being recovered. You put that into context, and I'm grateful for that. And the Public Accounts Committee, and I quote, this is not what I'm saying, it's what they say, described the, quote, rubbish performance of the agencies involved. Of course, Home Affairs does not use such emotive language as that. Having said all that, what can we do to help you? What changes in the law will allow you, as head of the NCA, to go after these serious criminals and get more money back?
Okay, can I point out some of the problems that we have? So you may have seen some of the coverage, again in the Evening Standard last week, on a civil recovery case. We took £4.5 million off a money launderer. That case was started in 2009. That's taken 5.5 years. So these cases are not quick, they are complex. I'll cite some ongoing investigations, but I'll name them because they're in the public arena. These people will do everything they can to frustrate us. So a man called Aaron Coughlin. Soccer started pursuing Aaron Coughlin through a civil recovery order. We are continuing to pursue him. He will use every loophole available through the civil courts.
And is he a British citizen?
Yes.
Residing in the UK?
Yes. So there's a real challenge about how long the process takes, particularly using a wide range of tools, including civil recovery and taxation, which we use to disrupt these people. It takes a long time. It's complex. It's also very risky. So a case that I know you're aware of, Chairman, the Israel Perry case. Again, a case that soccer started to take assets off a convicted criminal. There was then some case law that meant that we've had to spend significant resources defending our position that we inherited, and we've lost on some of that. The Abacha case is another example, £100 million of assets under control. So the first thing I'd say is really understanding the complexity, the length of time, the legal challenges we face is important.
Would it help if you were able to publish? These are people all convicted, they've gone through the system, it's in the public domain, the list of those people who are still subject to confiscation orders. Because you've talked about 3 of them today, we now understand the difficulties that you've had in trying to get at them. Would it be possible to publish this list? Is this one way of naming and shaming those who've still not paid up?
It is. Can I again just...
It is possible to publish it.
We could publish some of this, where there are outstanding orders. And much of it is in the public domain because some of the cases I've just mentioned, the Coughlin case, an example, is being conducted in open court. It's a court battle to take this man's assets off him, which we believe, and the courts believe, have been derived through criminality. So I know an area, Chairman, where you and I and the committee have not necessarily disagreed, but had a slightly different view, but if you can bear with me. One of the most helpful things would be to recognise the disruptive effect that taking assets off criminals can have.
We'll come to that in 1 second. I just want to push you on changes in the law. Is there nothing we can do in Parliament to help you? We're talking about criminals that have gone through the system. The court has imposed an order. They're out of jail. They still owe a huge amount of money. You're spending a huge amount of your time chasing people who've been through the court system. No change, before we come to disruption, any changes in the law that you would like to see that we can recommend to the Home Secretary or the next Home Secretary? So,
Chairman, we have very tough legislation. I think the interpretation and implementation of what is required of us is where the improvements are necessary.
By the judges?
By people like me, people like you, Chairman, and the committee. So if we go back to where we started, exposing some uncomfortable truths about how much asset can be actually recovered is really important so that we are focused on delivering what we can, rather than constantly harking back to a number which, I don't like it. I don't want criminals having any assets, but I don't want to chase assets that aren't there.
You mean at the time of conviction and sentence, this inflated figure is put out, we will take this much assets from you, but you're telling us there's no way they even have those assets that are recoverable?
No. And I think the more that we can focus on what is available and what we're doing about it and the effect we're having, that would be really helpful to us because we have very strong legislation. It's about the implementation of the operational response. And to be clear, I am dissatisfied with where we are because as long as criminals are benefiting from their crime, I remain dissatisfied.
Yes, I allow you to go on to your point on disruption, which you want to do.
I think really positioning the regime in what we're trying to achieve and trying to get a consensus around that is important, rather than chasing assets that either don't exist or assets for the sake of assets. I mean, part of the problem we've got in the gap now between outstanding orders and what is enforceable is born of chasing the number of orders as big as possible. What we have to do is focus on the disruptive effect that we can possibly have against criminals. And that's our top priority, and any support you can give us in amplifying the importance of that would help us enormously.
Thank you. David Winnick and then Michael Ellis.
To lead on to 3?
Yes.
Can I just, before I ask you about what's happening in Calais, can I ask you Mr. Bristow, arising from what you've just told the Chair, are the banks cooperating fully with your organisation?
So one of the points in the government's serious and organised crime strategy is the importance of helping the banks and other financial institutions understand some of the risks that they face, and because they face those risks, citizens and the reputation of our country faces. So we are open with the financial services industry, including banks, about the nature of the threat. We're working at the moment with the banks to agree information sharing protocols that will give us opportunities to target criminals in a way that we haven't before, that goes well beyond the SARS regime, which is the statutory regime where we need to be informed if there's a suspicious transaction. And the banks are being cooperative. We're still working through the detail of that, but I'm very optimistic that it's a good step in the right direction.
You see, arising from what has been occurring, or at least very much now in the public arena over Switzerland, HSBC, tax havens, offshore islands and the rest, do you explore all this? Because clearly the criminals can't all keep the money under the mattress. They must find various outlets, and banks would be one of the obvious examples where such money may be located.
So I want to choose my words carefully because I don't want what I'm going to say to be overinterpreted, not by the committee, but those that be listening. Because of the nature of our banking industry, the trillions of pounds that go through it every single year, the political stability that we have, the established nature of the industry, the sort of people that we're interested in will, of course, be laundering money through the UK banking system. The banks, for the most part, of course, don't know anything about that. It's merely transactions, high-volume transactions. But that is a reality. That's why the banks want to work with us to ensure that we have access to the intelligence that we need about criminals, not law-abiding citizens, criminals, and they use the banking system to launder their money or move money around the planet. Because the majority of people we're interested in, apart from those who are pursuing a sexual interest in children, it's all about the money.
So, as far as you're concerned, all the banks in the United Kingdom are cooperating fully with the National Crime Agency?
No, I'm not saying that. What I'm saying is there's a statutory regime that requires cooperation.
Requires it, but let's get to the point. Are there any that are not giving you the cooperation which you require?
There are a number of banks that, on the back of a meeting that the Home Secretary, the Governor of the Bank of England and the FSA hosted, a breakfast meeting last year, are agreeing now a regime with us that goes beyond the SARS regime to help us develop the intelligence, actionable intelligence we need for people who are using the banking system inappropriately.
I just want to get you onto this particular point, because I consider it, I'm sure other colleagues do, of much importance. I asked if all the banks are cooperating fully, and you have qualified that in a perfectly frank and honest answer to me. So I can only conclude there are some banks that are not giving the cooperation that they should be.
Not all banks are the same, of course. They go from the big high street retail banks, the investment banks, to small, I think what are called boutique banks.
Yes.
We are working with a number of the big ones to ensure that they are discharging their not only lawful but also ethical responsibilities to help us do our job.
Are they doing so?
We're on the cusp of a really big step forward.
Well, you've qualified it, but you've given a very frank answer, and we'll reach our own conclusions, Mr. Bristow. But I'm sure you're doing all that you possibly can.
Mr. Winnick, the only reason I'm qualifying it is because it's a qualified answer. I'm being open with you.
As far as Calais is concerned, the criminal network which exists in human trafficking and the rest, much progress in trying to undermine such criminal activity?
So we have a responsibility, of course, to ensure in particular the intelligence flows work to present opportunities to law enforcement to target groups that are involved in trafficking people, whether that's clandestine entry, modern slavery. One of the things that we've done is embedded an officer within French law enforcement to get to the benefit of our intelligence picture and their intelligence picture to provide actionable intelligence, tactical opportunities to target those involved in trafficking. And that's starting to show some really good early results. Much of the work is being led by the Joint Border Intelligence Unit in Kent, led by Kent Police. We're part of that. It is about bringing the intelligence picture together and intervening robustly against the trafficking groups.
The last question from me on this particular aspect. I went with 2 colleagues from the committee to Calais and certainly got the impression from the French that there's no easy answer, to say the least. And what has happened in the last few weeks, where people have been coming in to Europe, to Italy, and so on and so forth, I mean, it seems such an open-ended problem that it would be very difficult, won't it, Mr. Bristow, for the law authorities to deal with the human traffickers, because people are willing to risk their lives and do so. Hundreds have died in the last year in trying to get to Europe. So it's a very difficult one and complex, and seems to be getting worse than otherwise.
And of course, it's a range of problems. It ranges from people who legitimately want to come to the UK, they believe they want to be here, through to people who are conned into coming to the UK, through to people who are forced to come to the UK. It's a range of difficult, complex problems driven by instability elsewhere in the world and the real or perceived benefits of being here in the UK. And I know you know this, if it was a simple problem, we would solve it. It is about persistence. We're not responsible for controlling border entry. We are responsible for providing the intelligence opportunities to tackle the groups that are benefiting criminally from this awful trade.
Thank you. Tim Law.
On the back of the Calais situation, and I was one of the members of the Select Committee who went to Calais, and we spoke to migrants there who were quite open about having been trafficked, having paid large sums of money, and going round the town and actually pointed out where some of the traffickers were living, often alongside some of the temporary camps of these migrants. And there seemed to be very few cases of the French actually prosecuting them. Now, if that was happening in the UK and we knew who and where those traffickers were, surely we would be taking action against them. Why is it not happening in the case of France?
So, yeah, it is right to say that if we knew where the traffickers were in the UK, we'd be targeting them, whether that's us, the police, or other agencies. Part of what we need to do, I think, is add to the intelligence picture in France to help French authorities, who, from our perspective, from an NCA perspective, have been very committed to working with us to position the interventions in the way that you said to target the traffickers. And if you've got examples of where that hasn't been happening, it's very useful to know about those examples, because that helps me challenge ourselves and our partners to do more.
But it was freely acknowledged where and who these people were. There seems to be no lack of intelligence, with or without the good services of yourself and your staff placed over there. There appears to be a reluctance actually to prosecute them by the French, and all the time few of them are prosecuted, more people are brought over, added to which, of course, there's the problem about the actual migrants themselves are not detained. If they are caught, they are picked up and deposited 2 miles out of town without any identification procedures having been followed at all. So the whole process goes on, and traffickers continue to profit from it. What should the French be doing, and what pressure can we, and your outfit in particular, bring upon the French to make sure these people are dealt with?
So one of the challenges that we have generally with trafficking, whether it's people, drugs, any sort of contraband, firearms, is quite often source countries and transit countries don't necessarily understand the impact of the criminality when it arrives in the UK, and the same is true for other countries. So a primary concern to us is to point out exactly what's happening and the impact of the criminality on the UK and why it's important. That's something the NCA can do. But I think in terms of accounting for what the French authorities do or don't do, that's not for me to justify, and I would say as a parliamentarian that's an entirely legitimate challenge. My job is to provide the intelligence and explain the threat.
No, I understand you're being very kind to the French, but you would agree that if that situation prevailed in the United Kingdom, it is much more likely that you and the police forces in this country would take action against those traffickers.
If we knew where members of an organised crime group were who were involved in trafficking people, we or the police or immigration enforcement or others would be targeting them.
And just to go back to the source of the problem, because I think many of us would agree that by the time they reach Calais, it's too late, and we need to be doing much more working with other EU countries and other enforcement agencies in Italy, in Greece perhaps, of stopping these people coming into the EU in the first place. What action is the NCA taking, or what further action could the NCA take to work with partner agencies in those countries?
So part of our overall strategy in the formation of the Border Policing Command was that from point of entry, through transit, through to source country, we try and push the challenge away from the shores of the UK. We did inherit a very able and mature international liaison officer network from SOCA. I believe we built on that legacy. We've grown it, we've developed it. We're challenging more areas of criminality now than we were. And quite often, where it's appropriate, the work that we're doing in region alongside other law enforcement partners is having a big impact. So on modern slavery and people trafficking, for instance, we'll often have a regional plan which involves not only host countries but other law enforcement agencies working alongside us. And that is starting to have a real effect.
Okay, can we come on to a completely different subject, and a subject in which I questioned the Home Office Parliamentary Under Secretary earlier, and that was a recent fraud case which came about in December, and Judge Wendy Joseph, who instructed the jury to collapse the case, was exceedingly critical of the NCA in the way it pursued that fraud case. Quite a big fraud case involving £40 million, 200 bank accounts and several institutions. It wasn't just criticism of a few procedural errors, it was fundamental incompetence which he was targeting the NCA for. How did that come about, and can you assure us that that was a one-off, or what lessons have been learnt from that experience?
Okay, so since the NCA went live, we've made about 4,000 arrests, and we've secured over 400 convictions. That's about the pipeline. It takes a while for the people that we're prosecuting to come through the system. I read the criticism. We, with the CPS, have initiated a review. We're proud of our 92% conviction rate, many of which are guilty pleas. It's very clear that that trial did not go well, and there are very real lessons for us to learn. Some of that's at an individual level. There's often issues about systems and how evidence is presented that manifested in this particular case, and those improvements will be made. There were some very real lessons from that case.
What do you think the real lessons were? What did actually go wrong in that case so badly?
My sense is that some of the officers may not have had the support and guidance that they perhaps should have done for such a complex investigation. What I would say is, for the organised crime group involved, this is not the end. We are continuing to investigate them, and will continue to seek out opportunities to disrupt them.
That raises the whole point of the competence of the economic crime section within the NCA, and that's one of the 4 command pillars of the NCA, and obviously dealing very often with very complex specialist forms of crime. Are you happy that you have the expertise within that command to be able to deal with similar complex cases in the future?
So I think it would be, whilst it's absolutely legitimate to raise this particular case, I think it would be wrong to assume that that is the standard of investigation and prosecution that we're pursuing across the piece, because we are not. We have competent, able investigators. It is fair to say that we didn't inherit an enormous amount of economic crime capability from any of the organisations that we brought together to create the NCA. So we're learning, and we need to learn quickly, because some of the crime that we are targeting has not been targeted in this way before. So some of the work on corruption and bribery presents very real challenges for us. It's a complex landscape, economic crime, lots of agencies, lots of niche types of criminality. But we have able investigators. There are lessons to learn from that investigation. They will be learnt and they will be implemented.
So finally, are you implying that you're playing catch-up in Economic Crime Command compared to, say, something like CEOP, which came in, obviously, with a great deal of expertise already there, a finished product in many respects, that you've had to go out and recruit more people who are still finding their feet? Could that explain for some of the problems that we've seen in that trial and perhaps a few others as well?
So we've had some fantastic success around economic crime, and I know of more that will come and that you will see. But I don't think I can be more candid than I have been. So from SOCA, for instance, we inherited great capabilities overseas. From CEOP, very able people around child exploitation. But whether it's on the National Cybercrime Unit, or it's on economic crime, or in border policing, the very reason the NCA was created was to stiffen up the response to this type of criminality, and that means we're having to build capability. That's different, though, to saying that we are not capable of doing our job. We are absolutely capable, but we are going to get better and build greater capability.
Mr. Ellis, I called you next, but I think Nicola Bagman has a quick point on something.
I'm quite used to being last on the committee, Mr. Chairman. So
Mr. Ellis can go
No,
first.
she's deferring to you, Mr. Ellis.
I don't mind for Miss Blackwood. I'm quite happy to defer to Miss Blackwood at all times.
Are you sure?
Yes, Mr. Chairman.
Right, you're very generous. Miss Blackwood.
My quick supplementary was purely to ask, what are you doing to build up that capability? Are you partnering with economic specialists in the same way that you do with cybercrime and in other areas, in sort of the private sector, for example, because it is a very technical field, economic crime. And I'm just wondering what is being done, what is the nature of your economic crime unit, because I'm not aware of that.
Okay, so the first thing we've done is we've recruited a director who knows exactly what he's doing, Donald Toome, who was Director of Criminal Investigations at HMRC for some years. He's now Director of Economic Crime. This is a person who's got the right sort of background for what we need. And he is focusing the command in on its coordination responsibilities with the police and SFO, HMRC and others, and being very clear about the niche capabilities that we bring to support the overall effort. So some of the high-end capabilities we have as an agency, lawful interception of communications, as an example, our overseas reach. We bring that to bear on economic crime the same as we do on other types of criminality. Where we're investing heavily at the moment is on our money laundering capabilities, our ability to follow the financial trail, not just for asset recovery, but to disrupt criminality as well. And we're also in the process, in line with the anti-corruption plan, bringing together a national unit that will focus on corruption and bribery by bringing together specialists from the Met, the City of London Police and our own existing capabilities. So we are going through a process of building those specialisms.
So how many individuals would you say you have under your command in the economic crime unit, and then how many can you bring to bear on a case with all those other sort of locations that you just mentioned, so SFO, HMRC or whatever? So if we're talking about a really big trial, complicated trial such as this, who can you leverage in, but also who do you have under your own command when you've got a number of complex trials going on?
So the operating model for the NCA is we keep the commands as lean as we can, and they only hold the specialist capabilities they need for that particular threat. The vast majority of our workforce and capabilities sit in the Intelligence and Operations Directorate, and this is the way in which we're now targeting broader crime types with the resources we inherited. So those officers and those capabilities, we then decide through tasking with our partners where we need to target them and on which type of criminality. So if we're pursuing a complex corruption case, for instance, we would then task our officers in the Intelligence and Operations Directorate to support their specialist colleagues in the Economic Crime Command to assist them with that particular operation. That's how we built a flexible agency.
Thank you, Mr. Chairman. Mr. Bristow, your organisation's too bureaucratic, isn't it? I mean, the taxpayer is putting a great deal of money into the very important work that the National Crime Agency does. But how many tiers of management and commands do you have? How many of your resources are deployed on pushing paper around? What can you say to this committee to reassure us that the work of your very important organisation is directed where it should be at finding these evil people who are engaging in these criminal activities?
So our priorities as set by the Home Secretary are very clear. This is an operational crime fighting agency. That's why 85% of our officers are in operational roles. We did inherit, in my view, a top-heavy management structure. Not too many layers, but too many people in the upper layers. So,
and what have you done about that?
Well, we've had about 250 people, mostly senior managers, leave through early voluntary exit since we started. And we've got another 167 leaving before the end of March. And what we're doing with the funds that we're releasing, when we have got savings to make, is we're recruiting people lower down the organisation as operational crime fighters to reshape and rebalance the organisation.
But you had, I mean, just by those numbers alone, 250 managers and another 167 leaving. How many people were those managers managing? I mean, how many, on average, people were there under one particular manager? 5, 10?
So there's a challenge we've got in terms of how we shape our workforce. So if you can bear with me, let me give you an example. So let's go back to a conversation we had earlier about civil recovery. We need more lawyers who are expert in civil recovery than a police force would need, because that isn't what a police force does. If one wants to recruit lawyers, you can't recruit them where you've got one set of management grades at the lowest grade because you don't pay enough. So what's happened historically is that people have been recruited further up the management grade, so it looks like one has an awful lot of lawyers that are managers when actually it's about paying the going rate to attract lawyers. So one of the things that we're having to do is differentiate more clearly between professional and technical pay and managerial pay. So in some cases, we've had people that are on quite a senior management grade who aren't managing many people at all, but that's the way that we attract and retain those specialists, because we don't have separate pay structures.
So you accept that you've had people on presumably very high salaries in management grades who are there because you feel you need people who will only accept salaries of those sort of numbers?
We're not going to recruit, if I pursue the same example, we're not going to recruit a lawyer who's expert in what we need at £20,000 a year. So we've had people who have in effect been on a management grade because their technical expertise, we need to attract and retain them.
As far as the taxpayer is concerned, they would want us to seek reassurances from you that, with respect, we can't just take your word for it. Why is it that you are satisfied that you're able to lose hundreds of managers and still do the job that you can do, and not perhaps lose more managers? Convince us that you shouldn't actually be losing another 30 or 40 managers as opposed to the 167 you're losing now.
I'm sorry, I agree with you. I will convince you that I'm going to reshape this organisation to deliver as much operational effect as possible. We've lost 2 directors. We've downsized the board. What one needs at the beginning of an organisation is quite different as the organisation starts to mature. And in my judgment, we'll have a clearer set of arrangements for technical grades, we'll have a clearer set of arrangements for management grades, and the structure around management grades will give sensible ratios and spans of control for those managers. I'm not in the business of wasting public money.
Good, thank you. Now, it's judges who make the confiscation orders, isn't it? Do you have any problem, or do we have any problem persuading judges? I put this to the Minister. Is it an issue where the judges are not making these confiscation orders, or is it some other type of problem? Have you experienced cases where, despite the prosecution asking the judge to make a confiscation order, he or she has said, well, there are no assets that I can see here, and therefore I'm not making a confiscation order because it would be a waste of time? Are you getting that type of problem?
Sort of referring back to Mr. Loughton's point earlier, there may be cases where there have been isolated incidents, but for the most part, if we set out the evidence, and most confiscation orders secured by the police, not the NCA, we're targeting a small cohort of criminals. If we make out the case, we find the courts are sympathetic and supportive, giving us the opportunity to take assets.
If you make out the case, which is how it should be.
Which is our responsibility.
And it's up to you, the NCA, to recover assets, perhaps through third parties like the CPS if necessary, where there is an order. So you mentioned to the Chairman, I believe, a couple of examples of cases where there has been an order made for the confiscation of criminal assets. Presumably, the criminal in question has not had assets to recover, and then at a later date, he or she will have assets to recover, and there are a certain number of orders totalling millions of pounds, tens of millions of pounds, that you said fall into that category. So, old cases where nowadays the person has assets to recover. It's up to you to go back and recover those assets, isn't it?
The responsibility to enforce the order falls to the court and CPS, not to the NCA. We are part of the dedicated asset recovery team that we have set up with our partners, because our focus is on disruption of criminality, and actually enforcing the order delivers disruption. So we think we've got a stake in this, but it's not our responsibility to enforce the order.
Do you make any effort to tell the court service that it's our understanding that this person now has assets when they didn't have 5 years ago, and it's time that you go and recover them?
Yes, the people that we're most interested in, we expose them to what we call lifetime management. So once they're on our radar, whether they're in prison or they're at liberty, and where we have an order, such as a confiscation order in place, it provides us with opportunities. We manage them non-stop.
Right. I noticed something else you said about the layers of appeals that certain individuals are going through. But isn't it up to you to make representations to government to say, there are too many avenues of appeal here. This is something we were experiencing within the immigration arena. And at one point before this government, there were 17 tiers of appeal, and they have now been cut down significantly. No doubt if you, the respect that you bring in the office that you hold, make representations to government and say there oughtn't to be this many appeal processes, because it's no good complaining about someone who is using the law. It's up to you to persuade government to change the law if you don't think there ought to be that many appeal processes. Isn't that right?
So on civil recovery, we should remember that in effect we're going through a civil process, not necessarily legislation and courts that are specifically around asset confiscation. And we consistently set out to ministers, and ministers are supportive of some of the challenges that we face, but also some of the risks that we carry. So we will have actions taken against us for tens of millions, if not hundreds of millions of pounds, where individuals will claim they've lost opportunities to invest or we've disrupted their business. But the reality is, if they're criminals, we need to be brave and relentless in going after them. But this is often quite a risky process.
All right. Now, my final question is this. Just at the end of last year, I think in December of last year, the Prime Minister announced that there's going to be a joint unit between the National Crime Agency and GCHQ, General Communications Headquarters, to tackle the worst forms of child abuse online. How is this unit, have you set it up? When is it going to be set up, if it isn't already? How is it going to address the challenges of analysing imagery hidden on the dark web? And one of the reasons why it's sometimes been considered historically difficult for agencies to work with security services is because of the requirements of the courts for full disclosure. Do you anticipate problems working with GCHQ in the requirement of those seeking to defend themselves that they have full disclosure about GCHQ tactics, which would not be in the public interest to disclose?
Okay, so sort of in the spirit of what you've just said, Mr. Ellis, I'm going to put a bit of a caveat before I answer your question. So this is being broadcast. I've absolutely no doubt that people that we are interested in who would exploit children are listening to this broadcast, and if I say too much, if they're not listening now, it'll be out through their networks.
We certainly don't want you to do that.
So I know you don't want that. I am happy, if I can, to give more detail privately, but I will seek to answer your question as much as I can. So we have very good relationships with the agencies, all of them. GCHQ are being particularly helpful in our joint efforts to target those with a sexual interest in children. Without wanting to go too far, part of where the unit will start is how do we get the full intelligence dividend out of seized media?
Yeah.
So let me give you an example. Operation Notarise, we seized nearly 10,000 digital devices. You can imagine the amount of analysis that's required, not only to secure the evidence, but also so that we act appropriately around disclosure of any information that's relevant to the defence.
It's huge.
It's huge. GCHQ are absolutely expert in their ability at getting the value out of bulk data. So one of the places that we're going to start is how do we get the intelligence dividend out of the media that we've already seized? That's an example.
So they can help you with analysis, things of that sort. How best to manage it.
And, you know, I've discussed this with the committee on a number of occasions. One of the challenges that we as a society face, and the NCA and law enforcement are right in the centre of this, is the real risk to children in terms of image offending. The risk is hidden in volume.
Yes.
Getting through the volume to the risk and targeting the risk quickly, there is no zero risk option. We have to continue developing our methodology to get that risk quickly and manage it.
Well, I appreciate that, and I appreciate that it is sometimes a needle in a haystack with the vast volumes that you're dealing with. And
thank you, Mr.
I wanted to thank you for the work that you and your personnel are doing.
Thank you.
Thank you, Mr. Ellis. Just in respect of one of the points raised by Mr. Ellis, you took over from the Serious Organised Crime Agency. They had staffing of 3,990, according to our last report. You started 2014-15 with 4,041 members of staff. In answer to Mr. Ellis, you seem to imply that 417 have gone. So you've lost 10% of your staff.
No, Chair, that's what you said is reasonable, but what we've then done is we've recruited officers lower down the organisation that give us the capabilities we need. So,
right, so you haven't lost 440?
No, we currently have 4,569 officers. So even though our budget has reduced, we are managing to grow the workforce by reshaping it with less senior people and more people going to put hands on criminals.
So it's gone up from 4,041 to 4,500?
The full-time equivalent, so that includes part-time workers, the full-time equivalent is 4,267. So we are managing to grow the organisation by reshaping.
And how many in your organisation formerly work for soccer?
I would need to come back to you on that.
Would you? Thank you.
May I make a more general point about workforce size? Well, one of the challenges I think it's a challenge for the police, but it's particularly for the NCA. And I know you know this, but it's worth saying again. I think in the sort of criminality that we're tackling and the capabilities we need, we have to stop trying to judge the value of an organisation by how many people work for it. It's an entirely legitimate question. But part of the rebalancing we're going to need to do is to invest in our digital and technical capabilities, going back to Mr. Ellis's questions earlier, and that isn't necessarily about more and more people. It's often about better qualified and able people who are able to operate in a digital environment and get the benefit from the technology.
Indeed.
So there is a reshaping, Chairman, that we're going through.
Very helpful.
And I very much want us to be judged by what we actually deliver for the public.
Thank you. I think Nicola Blackwood had a quick supplementary, then Dr. Hubbard. Is that right?
Mr. Chairman, I just wanted to come back on a comment that you made to Mr. Ellis. That is, you're in the business of disrupting serious organised crime. Obviously, I'm an Oxford MP. We had a very serious child sexual exploitation case, Bullfinch. And one of the most useful tools that they've had are abduction notices. And also the government has recently passed a number of new prevention orders, the sexual risk orders, the trafficking orders. They've changed the thresholds for gang injunctions. Talking to some police officers, they've been trying to understand how this new architecture will all work together to make sure that this actually leads into prosecutions rather than the orders just being ends in themselves. I'm just wondering what your comment is on that and how you think the government can most effectively put forward guidelines to help officers on the ground to effectively disrupt child sexual exploitation, but also bring forward more prosecutions in what's actually a very difficult field to investigate and prosecute.
So, child sexual exploitation, the way that you describe, is often a local problem requiring a local intervention. Quite often that means, therefore, that we have specialists within police forces and other agencies working alongside generalists. And one of the challenges that we always have with generalists, whether they're constables or police staff delivering these important interventions, is helping them understand and know what they need to know to do the job on the ground at that time across a whole broad range of issues. I know that ministers know that, and I know officials are working hard at making sure that sort of guidance is available to help officers make those particular judgments. But much of that is a policy issue rather than an operational issue. But I know they are minded to make sure that guidance is available.
So, firstly, just to pick up on something we've discussed a number of times before, Project Spade,
yes,
and the failures with Miles Bradbury in my constituency and elsewhere. And I don't want to go through the whole history of it. I spoke to the Home Secretary afterwards, where she said that one of the changes that was being made was that rather than just looking at the level of harm in the images, the individuals who had been accessing them and their risk, in this case a paediatric oncologist, in another case a deputy headmaster, would also be looked at in all cases. Is that now right? Is that now happening in every single instance where there is child abuse imagery?
So, again, if I can put a caveat on what I'm going to say, you know, Dr. Hubbard, that we are, and others, are subject to an IPCC investigation. I don't want to say anything that's going to make their job impossible, but I will answer as best as I can. So, the first thing that happens when we receive a referral, which is often data accompanied by an image, is we assess that immediately to see whether, based on what's in front of us, there is an immediate risk to a child or young person of harm. If there is, we then prioritise the process of trying to turn that data into a location and a person, actionable intelligence. If that isn't the case, so there isn't an immediacy, we then need to work very hard to identify who the individual is for exactly the purpose that you've just said, because we are prioritising looking at the individual and their access to children rather than the harm demonstrated in the images. They're both relevant, but I think the hard lessons that we have all learned, even more so for victims, is that where we have to start is who is the person accessing the images, because there is a link between images, which is an abuse in itself, and contact abuse. I know you know that from constituents and elsewhere. So that has happened, but I wouldn't want to oversimplify it or give you a level of reassurance that was unrealistic. This is difficult work, and quite often turning partial data into a location or an individual for us to assess is impossible.
I do appreciate the challenges, and I'm glad that the lesson has been learned when it wasn't even attempted, as I understand it, on the previous Project Spade data. But can I then move on to broader issues about cyber criminality? And I put this to the Minister earlier. How well do you think we're doing in tackling cyber criminality in its broader senses? Are we just nibbling at the edges? Are we actually making a profound difference?
We've got a way to go. So if Mr Loughton's question about economic crime had been about cyber, and I think he said something like, so we're trying to catch up, I think that's true of cyber. I think we're narrowing the gap between the ability of the criminal and the ability of law enforcement. And I can point to some fantastic examples where we've disrupted the most serious type of cyber criminality, which is virtually always overseas and highly complex and not just targeted at the UK. But it is fair to say that we're not going to make the progress that we need to make until we shake off the misplaced belief that cybercrime is niche. The reality is, if you look at the bulk of criminality that the police and others deal with, and we have a role in, much of it now is cyber-enabled. So fraud, child sexual exploitation, blackmail, many of those now are cyber-enabled. And even if it's cyber-enabled, people have a digital footprint in the way that they lead their lives. So trying to prove that someone was in a particular location, booked a hotel, communicated with someone is all about digital capabilities. It sort of goes back to the point I made to the Chairman earlier, that certainly for the NCA, we need to judge the agency by our capabilities and the effect that we have on criminality for the public, rather than the number of people that work for us, because that will hold us back if we do that. We need different partnerships with industry. We need better capabilities. We need to focus on how we find the risk in the volume. And some of the uncomfortable contemporary law enforcement responses, which are often criticised, like action fraud, are a reality of a changing type of crime, where there was a time during my career where crime in a particular town was usually perpetrated by somebody from that town. And fraud was a face-to-face type of criminality. That simply isn't the case now. And whether it's Brisbane or it's Bournemouth, the reality is the thing that we share is language, which means there's new criminal markets, prosperity, access to the internet, which means we are ripe for targeting by criminals often from abroad who seek to exploit citizens in those countries. It means a different way of thinking and working.
But I think that's very helpful. How do you think you're doing in getting it taken out of that niche? Do you think police forces in general around the country appreciate that yet?
Yes, I think so, in general. I think giving effect to that belief is more challenging. My assessment would be at the national level, not just the NCA, but our partners as well, we're making very good progress. The Director of FBI, who I have a good personal relationship with, and our agencies work well together on cyber, his and their view is there is no better operational partner in the cyberspace than the NCA. We work very, very well together. I think the regional capabilities are developing quickly and are starting to have an effect, but there are real challenges at the local level to balance all that we were talking about. Blackwood was talking earlier about child sexual exploitation within communities, contact abuse, right the way through to fraud and cyber-enabled. I think there are real challenges about rebalancing.
And one last subject for me, if I may. You were talking about hiring more staff at a more junior level who are actually engaged. I suspect that there is a shortage of police staff, people in this space, who are very familiar with the cyber world. Are you able to recruit all the people that you need there?
Let me share with you a little bit of learning for me since I first came into this job in 2011. I think I'd underestimated how much we need traditional investigators working alongside cyber experts. Because cyber experts understand the technical route through which we do things, but until we can train them as high-level investigators, they need investigators sat alongside them who know the rules of evidence, how to arrest offenders, how to bring people to justice. So there is a balance in how we develop our workforce and go forward. So we're taking a really innovative approach to this. We've got apprentices now joining us through a joint apprenticeship scheme with GCHQ. We have cyber specials, which we are growing very, very quickly. The sort of people that we're recruiting now, those that are replacing managers that have left, might not be people who would want to pursue a career in policing. They might have thought about all sorts of other options elsewhere, but we offer a niche career for them working in that digital space. So it's challenging, often around what we pay. It's challenging to retain people, but we have to focus on what it is that we're doing for the public and the importance of that.
Thank you.
Can I make a more general
well,
point,
only
Chairman?
if it's very brief.
Very quick. I think in terms of the future of policing, coming back to your original point, I do think, particularly if driven by austerity, we need to think more clearly about what local police forces do, what regions do, what national agencies do. The capabilities should then follow those responsibilities, as should the funding. I think it needs a more rational model than we have at the moment, because at the moment, everyone's trying to do lots of things, and I'm not sure that it's wholly rational nor affordable in the future. So some of our digital capabilities, an example, there's no point in the NCA doing things that every local police force can do. That doesn't seem rational to me. So distributing the capabilities more sensibly around the responsibilities so the whole system can have a greater effect, even though it seems to me money is going to come out of the system, is a real challenge for policing and the NCA.
Mr Bristow, this is probably the last time you're going to appear before the committee before dissolution. We want to thank you for all the work that you and your team have done. It's been a difficult start for you because you're starting a new organisation. And as we've said in our last report, you've been very open and transparent with the committee. But Parliament will continue to ask these questions to get value for money. And we need those answers, such as the answers you've given today. And I hope very much that you will continue to work with our successor committee and give us the answers that you have done in the past in a very clear and open way, which is quite different from your predecessor and your predecessor's committee. Thank you very much.
Thank you for your support, Chairman, and for the committee. I think we've made a very good start.
Yes.
There have been some challenges, but we're doing things now for the public that were not possible before, and the public is safer as a result. So thank you for your support.
Excellent. Thank you very much. Order, order. Could we have the next witness, Mr. Ian? ACPO Criminal Records Office. For coming. This is a one-off session just to look at the work that you all are doing at the Criminal Records Office. In the time that I've chaired this committee, we've not had any evidence from the head of the Criminal Records Office. Perhaps I can start with this question. The concern of the committee, I think the public, is to make sure that those who enter the country, foreign nationals, are able to be checked in a quick and efficient way against databases. If you could tell the committee how many people are currently checked against databases once they are in this country and if they're committing any offences.
Yes, Chairman, I can. Up to October of last year, the amount of checks taking place through the ACPO Criminal Records Office was about 4,000 a month. You'll then be aware that there was significant concern expressed about that volume, both by the Home Secretary and by your colleagues elsewhere in Parliament.
Well, this committee.
And this committee. And a sea change has taken place since that time.
Since October?
Since October. Chairman, I have the figures for every month, and I thought perhaps your committee would welcome if I gave those to you. What that shows is that we went from 4,000 a month to up to nearly 10,000 a month.
Yeah, so from October to November, following the concerns with some very high-profile cases of foreign nationals who were arrested, the number of checks went up. Is it because you all are working faster, i.e. not having lunch breaks, or is it because more of the local police forces are ringing you up and saying we need to check this man against a database?
Chairman, I think it's a bit of both. There's no doubt that this rattled the cages of chief constables and significant effort by the Commissioner of the Metropolitan Police, encouraged by the Home Secretary, to check all foreign nationals. So that's both EU nationals and nationals from outside of Europe.
These are people who've been arrested, not people who've just arrived for a visit.
No, these are people who've been arrested. And across the service, you can see a similar effort taking place.
So just to get the process right, I'm, for one moment, the Chief Constable of Leicestershire. Somebody comes in there, they've committed an offence in Leicester. Prior to October, what percentage of the cases were being checked, and as opposed to November? How much is the percentage increase?
Well, prior to that date, on average, about 30%. So that meant that 70% of foreign nationals weren't getting checked at all.
These are people who had been arrested.
These are individuals who have been arrested and are either then subject of a criminal process.
Sure.
So you need to find out this individual's criminal history, because that's going to have an impact upon the way in which you either investigate the offence and or when the court deals with that individual, it'll have an influence on bail or tariff. So that's why it's so important to get the antecedent.
But now what is that percentage?
It's 60, I can give you, as of today, the last month, Chairman, 70% of EU nationals who were arrested in England and Wales have been subject to a check through ACPO, and 64% of non-EU nationals have also been checked to ACPO.
But, Mr. Readhead, even though that is a huge improvement, it's still not satisfactory for this committee. There is an assumption that anyone arrested who is a foreign national suspect should be checked against your records. The records are there, and 70%, 66% is actually not enough. Surely it should be 100% check, because some of the ones you don't check may be the most serious ones.
Chairman, it is a feature of this environment that we deal in risk. And you're quite right to identify that some of those individuals who are arrested for very minor offences, when we actually get their record back from Poland or Romania, we find that they've in fact committed very serious offences, and we then have to engage with our colleagues in Immigration and Border Agency to try and seek to get those people removed from the country. So I wouldn't seek to disagree with you on that the objective must be to
why
get to 100%.
Is it not 100%? Well, whether objective or no objective, it's now February.
Yes.
This whole issue became live in October.
Yes.
Surely you'd want to send out a message to every chief constable saying, we will check every single person. It doesn't take long to do this, does it? What's the turnaround? For example, someone arrested from Romania in the middle of London, and you go to the Romanian authorities and you check. What's the turnaround?
Well, the return date should be within 10 days, but I have to tell you, sir, the fact is that Europe differs in its ability to return conviction data to us. And we shouldn't be surprised about that, because some countries, such as Romania, are clearly getting together a system which is IT based and which is more able to respond to us than perhaps countries like Poland and Germany, who give us a return very quickly. Some countries we still don't get any responses.
Is that an EU country you're talking about?
Some countries within the EU are not even within ECRIS. That's the network which is operated.
So some of the people who are arrested here, who are foreign nationals but EU nationals, you don't even check. You can't check because they're not coming back to you.
No, we check them, sir, but what I'm saying is we may wait a long time to get the record to come to us.
And in the meantime, they could have gone through the court system or committed another offence.
There is a risk that during that time the record will not be with us, and clearly on the figures that I've given you, sir, 40% of people not being checked are going through that process anyway.
Well,
so that is the reality.
We would feel this is unsatisfactory because we would like to see an absolute 100% check. That's what the public and Parliament would want to see. What do you think Parliament can do to help you? Because you made this huge increase in just 1 month from 4 to 10,000, which is very commendable. But we need you to do better. What can be done to make this 100%?
I think it's around 3 aspects. Leadership. I think it's actually also to do with IT.
Sorry, whose leadership?
Leadership by chief constables.
Right.
They own the
So
responsibility.
the message must go out to chief constables that they've got to do this checking.
I think there is an issue that chief constables and the Commissioner of the Metropolitan Police has evidenced that he's able to raise the level of checking significantly as a result of mandating.
Is London 100% checked?
In London, it is actually 100%.
Right.
So that's different than the target
Sure.
that's been set to the police service, which is 60% of European nationals.
And
so
who set that target?
that was set by the Home Secretary, sir.
Right. Well, 100% sounds much better. What's the second thing that can be done?
The second thing is this. One of the complexities about checking a foreign national is this. If I arrest a Polish national and I don't obtain the Polish national's Petzl number, when I send that check to Poland, I get no response because that's critical to the way in which they run their criminal history.
What is a Petzl number?
It's like an ID number, but
Right.
that's peculiar to Poland. If I check a French national, I need to know the town in which the French national was born. If I don't get a response from France. So across Europe, the way in which we hold criminal conviction data and the critical points we need to get that check done is not consistent. So there's an issue there of making sure when I bring an offender to a police station and I'm a custody sergeant entering that data, it's a bit like booking an airline ticket. There's a kind of a fail-safe mechanism that once I know you're Polish, I need to get these other pieces of information because if I don't get that, the check won't happen.
What's the third aspect? Leadership, the European differences between countries. What's the third aspect that you think should help you?
Training.
How many people are in your records office at the moment?
320, sir.
And this is in Hampshire?
Yes, they're all Hampshire employees. They work covering a number of activities, and this area is the international side of doing the checks, going out to Europe where we're requesting information and then getting checks coming back in where we've had a UK national who's been arrested in Poland and has been subject of a conviction.
And if it's a UK national arrested in Poland, they'd come to you, would they?
They do. And we then put that conviction onto the PNC.
Right.
And it's a feature of today's world that about 30% of all the foreign nationals that we arrest in this country, when we go to Europe, 30% come back with criminal convictions. So we have to put those convictions onto the PNC.
Yes.
And about 30% of UK nationals who come to us, they've been arrested in Poland, and Poland says, what do you know about this person? They are also criminals. And so that shows, in my view, that criminals deliberately exploit the ability to cross boundaries, to go on committing crime and to evade capture.
And the training should be done by whom?
The College of Policing, and we're working closely with the College because we need to embed within police constables the need to get the right information, and they have powers to actually go and check an individual's country of origin, to seize passports, to get the right information so we can do the check.
Thank you. Mr. Winnick?
Yes, thank you. Following on what the Chair has said, when I questioned the Minister for Immigration last week, I did refer to cases where foreign criminals have entered this country, where convictions had occurred in their own country. And of course there was a notorious case, the killing of the young female, Alice Grass.
Yes.
And the offender, well, one assumes he was an offender, the prime suspect in the killing, who took his life afterwards, and the police are not looking for anyone else. I mean, that is a glaring case, is it not, of someone coming to this country who had been already convicted of murder in his own country in Latvia, comes to this country, allowed in, and then this crime occurs. That is a glaring mistake, surely, on the part of the immigration authorities. It happened, I know, some years ago, and I'll come to a more recent case in a moment, but that's a pretty terrible illustration, is it not, of what we want to avoid.
What that case demonstrates, and it is indeed a very tragic case, the loss of life of a very young girl, what that demonstrates is how key this is for us to improve our performance, to put in place the right procedures, to work closely with the Immigration Service and the border agencies so that we can protect our communities and bring offenders to justice, be those UK nationals or be they EU nationals.
Now, that was a case where the person came in a few years ago. But more recently, a burglary took place, as you know, in London. When I give you the details, you would know, where the male householder, a professor, academic, not really matters one bit what he did, was brutally beaten up, and the people involved, who have now faced justice in this country, had convictions in their own country. And that's more or less recently. So inevitably, Mr. Readhead, people say, well, improvements, we're told, are taking place. But this is hardly an illustration of that.
So it is a feature of freedom of movement within Europe that individuals who have been convicted of offences in their country of origin in Europe may well have been convicted of causing grievous bodily harm. Once they've served that conviction, some years later may well travel and come into our country in the same way as individuals in our country convicted of some serious offences and perhaps punished by prison, then leave our country and go into Europe as well. And I do understand the significant concern that exists in our communities because of that. So I think our focus should always try to be upon the most serious of offenders and how we manage and monitor them and their movement, especially those in the UK who have been convicted of sex offences, and putting them onto our violent sexual offenders register so that we can try and protect communities both here and in Europe from further offending from those individuals.
Now, when the Minister was answering my question last week, he said a lot depends on the information we receive from other EU countries. So if we're not informed, if the appropriate authorities at border level are not informed, that means, in fact, such offenders can come into Britain.
Well, things are changing, sir. I mean, the
In what way? Since last week?
The movement, sir, to the Schengen agreement, as you know, will produce a different arrangement in relation to individuals who are wanted on European arrest warrants, or individuals who are missing, or major property. And for the first time, the border force will have access to that system and will be able to stop people at the border who are coming in who are subject of such a warrant and detain them. And in case we have individuals in this country who are wanted on such warrants, of course, when they come to our attention as well, they can also be subject of an arrest and potential deportation. So there are a number of efforts to improve the situation, and I think we are making progress, but I don't pretend that there isn't a lot more effort needs to actually take place.
If you take, I'm not quite finished, Chair, if you don't mind. If you take, for example, where a disgraceful incident occurred in Paris, where it's alleged that the British people were involved, football fans, chanting disgusting racist remarks and refusing to allow a person who happened to be black living in France onto the train. If such people are identified and convicted by a British court, are they the sort of people that the French authorities will be told about, their identities given, so that France, if it so wishes, and one hopes that will be the case, will tell these racists they're not wanted?
That's a really interesting question, sir, because as you know, within football, individuals committing certain types of offences can actually be prevented from travelling and have their passport taken away from them. And so, my hope would be that if those individuals are held to account properly, let's hope that they don't go to Paris and cause that kind of disruption again.
Thank you.
Thank you. Dr. Huppert?
Thank you. Can I ask about data which you hold on people, particularly biometric information, and how the Protection of Freedoms Act is working in terms of deletions? Because you're responsible for that as well, I think.
Yes, sir. There are two methods by which individuals could seek to have records deleted by the police. One is called the exceptional case procedure. Now, that applies when, let's say, an individual is arrested by the police on suspicion of murder because he lives in a house of multiple occupancy of students and a student's been found dead and there's a suspicion that the other student has actually committed the murder. But some weeks later, it's discovered that the person has died of natural causes. So there's never been a crime. Now, in those circumstances, an individual can apply to the Chief Constable in order to have their records removed. Now, that's a fairly frequent occurrence. I brought the records for you today. In 2014, 412 removals took place nationally, and so far this year, 19. So that's in relation to no crime. In relation to biometrics, there is an early deletion process. Now, this occurs when an individual may have been arrested for a qualifying offence. Perhaps he's been arrested on an allegation of rape. And within POFA, there's a date period under which the police can keep biometric records. However, the individual can actually seek to apply to have the record removed early, perhaps because they're seeking occupation and they feel that inhibits their right to get work. Now, we manage that process on behalf of Chief Constables, and in 2013, since 31st of October 2013, we've dealt with 107 applications, and all have been dealt with within 7 days. So we are getting applications come through. My own personal view is that's a bit confusing, because you've got one process operates through Chief Constables and another process which operates through ACPO. So we've actually put a paper to Chief Constables suggesting that we manage all of that through a single port of entry, so it's more effective and more efficient for members of the public.
That does seem to be quite good, because there seem to be different views among a number of chiefs. I mean, I have a constituent whose son-in-law was arrested for an offence in London and was prosecuted for it. It then turned out that it in fact wasn't an offence, and the Magistrates' Court highlighted the fact that it was an unlawful arrest. And they've been trying to get the biometrics quite reasonably deleted. The Metropolitan Police's approach has been to highlight the fact, and they say this on their information, there is no statutory time unit for them to get round to processing requests. Do you think that's satisfactory, that the Met Police are highlighting the fact that although you can ask to get this stuff removed early, they don't promise to actually get round to looking at it ever?
Well, I don't know the occurrence, but I actually think that you're right in relation to this delay. And I'll tell you how I think I know that, because, you know, I told you we don't manage that process, but we do manage the reference numbers. And we've noted that there's quite a delay between when an issue was raised and when we've actually given the reference number. So although I've said to you 412 reference numbers were given in 2014, what I don't know is, when was that matter first raised? Has it taken a month or has it taken 2 years? So it may be true to actually say that.
I mean, right? So you don't have access to that? It would have to be the different police forces?
I don't have access to that, although I have access to the numbers.
I mean, it might be interesting for the committee to write to the forces, because clearly sitting on these decisions for a long time would not be appropriate. On another subject, you're, I think, responsible for freedom of information within ACPO, is that?
Yes, I lead for ACPO as their Director of Information. I lead for FOI.
We had long debates about whether ACPO should be subject to FOI. Yes. With the new change that's going to happen when it becomes a Chiefs Council, will your role continue with that, and will they be subject to FOI there?
So my role will continue in advising Chief Constables with regard to FOI issues. As you rightly say, the Association of Chief Police Officers was not initially covered by FOI, although we actually wanted to be, and we voluntarily complied with FOI, but actually that's quite meaningless, because the Information Commissioner has no power to protect applicants when it's only a voluntary process. So ACPO became a designated authority, and the concern that we've had is when ACPO actually goes into an insolvency process on the 31st of March, and we have the National Police Chiefs Council, will that body be covered by freedom of information? We've been in discussion with the Ministry of Justice, who covers this area, and the Ministry of Justice has said that in advance of the election there isn't time to designate the MPCC under the Freedom of Information Act. However, because ACPO will not be wound up until July, they believe that both ACPO and the MPCC, who will be handling and processing data on behalf of both organisations, that will mean that they're still covered under freedom of information, and the intention will be to designate the MPCC immediately after the election.
But your clear preference is for that designation?
Absolutely. There is the police service in this country must be transparent and accountable to the public, and freedom of information has done much to allow individuals to have access to what we do, to understand what we do, and for us to be held accountable through the legislation.
Very well. Thank you very much, Mr. Readhead. Now, the Minister for Immigration has stated to this committee previously that under this government we have seen a 700% increase in the number of checks through the ACPO Criminal Records Office of foreign offenders. A 700% increase. Can you confirm those are accurate figures?
I can, sir. The figures that are related to actually go back to 2010-11. In that year, we checked 8,172 EU nationals and 12 non-EU nationals. So we only in that year checked 8,184. In 2014, between April and December, we checked 38,836 EU nationals, 22,218 non-EU nationals, a total of 61,054 nationals altogether.
So there's been a 700% increase, which is a very good thing. How have you been able to manage that increase with your resources?
A number of areas. So the first is we've had to increase resources. When those figures commenced in 2010, our establishment was about 120. The establishment now at ACPO is 320. So a significant increase in resources. Secondly, we've had to improve productivity. And one of the things which we noted was how slow our systems worked. And so we've actually spent £200,000 over the last 4 months, and we've improved our productivity per person from 25 checks a day to 47 checks a day.
Is this better equipment?
This is making systems run faster, and so we're much more productive. The third thing we've had to do is when you get an increase so significant that it doubles your workload in a month, we've had to seek assistance from the Hampshire Constabulary, and we're paying overtime both to Hampshire Constabulary staff and also our own staff for weekend work.
So clearly there's an effort to increase resources, and it's a matter that the government is giving priority to. I noticed that you said that Sir Bernard Hogan-Howe has managed a 100% check rate. But this isn't happening in other forces. Is that right? Why do you think that is? Why is it the Metropolitan Police can do it, other forces are not?
The target set for forces outside of the Metropolitan Police is 60% of European nationals. However, when you look at what's happening, I think Chief Constables recognise that, in fact, it doesn't make sense to try and just target EU nationals. And if those figures that I want to send to you show that actually on both sides of the House the performance is coming up. And so although the target was only for 60%, the interpretation by Chief Constables is to improve performance.
So it's your perception that Chief Constables around the country are giving this a higher priority, and they are informing their staff that they should give it a higher priority?
For most, that's true.
Now, as far as the number chosen is concerned, in an outside of London force area, if they're reaching 70%, how are they deciding which foreign offenders are not checked or foreign overseas citizens are not checked? How are they making that decision?
When I said earlier on, sir, that the need was to train staff more effectively, one of the reasons why I say that is because you assume that an informed decision is being made as to who to check and who not to check.
Are you saying it's random?
My judgment is that most serious offenders are being checked, but after that, it could be
Well, this
random.
is what I was getting at. Is it likely that the 30 or so % that are not currently being checked are those that are perceived by the arresting police to be less serious offences.
I think there's a risk of that, sir.
Do you think it is achievable to reach a 100% target in the medium to short term?
No. And I'll tell you why we can never reach 100%. We don't have exchange agreements with a number of countries, such as North Korea, Yemen, Afghanistan.
Within Europe, let's say.
Within Europe, yes, I think it is fair to say the target should be 100%.
And is that achievable in the medium or short term?
I think it's achievable within the medium term.
How long?
I would be disappointed if by the end of this year we weren't heading towards having 100% checks. And the reason for that is because I think a lot of those technical barriers will be met and it will be an automated process.
Good. Well, we certainly look forward to that. Well, thank you very much, Ian Readhead, for coming before this Home Affairs Select Committee.
Thank you, sir.
This committee is now adjourned. Order, order.